grounds on which his decision was based. And the House must debate this statement within 15 days. The proclamation will lapse after 15 days unless extended by the House under Section 10. By Section 10(1), it can vote by simple majority to extend the emergency for up to 3 months at a time, and no more than 6 months in aggregate. And after those 6 months, Section 10(2) requires that further extensions of up to 3 months at a time may only be made by special majority of both Houses of Parliament. So the Constitution sets a clear procedure for the declaration and continuation of a state of emergency, which is begun by the executive but ratified by Parliament. Can the court review those decisions? Well, the Constitution provides that a proclamation is not effective unless it contains a declaration that the President is satisfied that there's a public emergency in one of the categories. Now, if he must be satisfied, applying ordinary principles of judicial review, we might say the court can subject his satisfaction to a familiar judicial analysis based upon the Tameside case. In the words of Lord Diplock, did he ask himself the right question? And did he take reasonable steps to acquaint himself with the relevant information to enable him to answer it correctly? That might entail checking that the President understood what he had to be satisfied of and assessing whether material existed from which he could reasonably be satisfied. So to do that, the first place the court will look will be the reasons given by the President, his statement setting out the specific grounds on which his decision was based. There lies a reason for caution on the part of the court. The statement is expressly for Parliament. It's to be presented to the House and debated. If the House has debated the grounds for the President's decision and found them adequate, there's an obvious reason for caution: respect for Parliament's constitutional function. The related reason is that the question whether there's an emergency is primarily a matter for administrative and political assessment and not a legal question. In the English case of A and the Home Secretary, commonly known as the Belmarsh case, the House of Lords said this was a matter of relative institutional competence. One issue in that case was whether the possibility of a terrorist attack could be said to be a threat to the life of the nation. Lord Bingham, with whom the majority agreed, found that there was no reason for the court to overturn the government's judgment that it was such a threat.